Supreme Court rejects claim Oyram West Cork holiday homes sale had no VAT liability. Three men who claimed a tax planning scheme meant they did not have to pay VAT on the Oyram sale of 15 holiday homes in West Cork have lost their Supreme Court appeal arising from decisions the scheme had no commercial reality and constituted an abusive practice as defined by the Court of Justice of the EU. The proceedings by Edward Cussens, Jennings and Vincent Kingston arose after the Revenue Commissioners said the complex scheme concerning the development at Baltimore did not permit them sell their freehold interests without paying VAT. The case involved analysis of the effect and application of Irish tax law, CJEU decisions and a European Directive, the Sixth Directive, related to harmonisation of the laws of EU member states on common systems of VAT. Giving the five-judge court's unanimous judgment on Friday, Chief Justice Frank Clark said he was satisfied it is appropriate to treat the relevant transactions in the manner contended for by the Revenue. While Irish VAT legislation does not provide for disregarding certain transactions found to be abusive, it was clear from a CJEU judgment in this case that national implementation measures are not necessary for the abuse doctrine, which derives from a fundamental principle of EU law, to be applied in appropriate cases, he said. He upheld High and Circuit Court findings concerning legal issues in the case, apart from a Circuit Court finding that no interest was payable on VAT.The. He said the interest issue was not properly before the Circuit Court but the taxpayers remain entitled to argue, in any appropriate proceedings, that interest is not payable. The three partners, on advice of Deloitte and Touche, had put in place transactions involving their entering on March 8, 2002 into a 20-year and 1-month lease with a connected company, Shamrock Estates Limited, which then immediately leased back the property to the partners for 2 years. On March 20, 2002, the lease and leasehold were extinguished by mutual surrender. Because the partners had paid some €40,000 VAT on the capitalized value of the 20-year and 1-month lease, they claimed they could then legally sell their freehold interest in the holiday homes without paying VAT on that disposal. An inspector of taxes held the VAT exemptions arose from a series of artificial transactions and VAT assessments were raised against them for periods in 2002 and 2004. They appealed to the Circuit Court, which found the leases were not void but also found the partners were simply leasing to themselves and surrendering back to themselves, and this amounted to an abusive practice contrary to the purpose of the Sixth Directive. Legal issues were referred to the High Court with a focus on whether the principle of abusive process could be applied. In 2008, Mr. Justice Peter. For more on this story, visit the news article link.